Hi, everybody. As some of you guys have observed and have heard, I've been having some vocal problems that have been getting worse and worse over the last year or two. But I'm also sick, yet there's this whole flurry of legal filings that have just recently happened in Donna Adelson's case. And I do seem to be able to speak a lot better and more fluently when I'm making wacky, weird comedic voices like my Donna Adelson voice. So this motion is actually unintentionally comedic. So why don't we just put on our sunglasses and put on the Donna Adelson voice so I can read this to you in a more fluid fashion. So here we go. Hope you enjoy it. Defendant Donna Adelson's motion to dismiss indictment for pre-indictment delay, or alternatively, to exclude evidence. Defendant Donna Adelson, by and through undersigned counsel, pursuant to Florida Rule of Criminal Procedure 3.190 and the Due Process Clause of the Fifth Amendment, respectfully moves this court for an order dismissing the indictment for pre-indictment delay, or, in the alternative, precluding the state from introducing exhibits or testimony at trial that she can no longer adequately refute because of the state's charging delay. Preliminary statement. This case presents an egregious example of pre-indictment delay. The state began its investigation with Mrs. Adelson among its prime suspects, just hours after Professor Markel's murder in July 2014. By 2016, the state had focused its efforts through witness interviews, document subpoenas, pen registers, surveillance, undercover operations, and wiretaps to charge her alongside her alleged co-conspirators. In fact, the state's evidence against Mrs. Adelson has remained largely unchanged since then. Yet the state made the intentional, strategic decision not to charge Mrs. Adelson for almost 8 years, choosing instead to pursue charges against 4 of her purported co-conspirators first. When the state finally decided to seek an indictment against Mrs. Adelson, more than 9 years had passed since the murder. By that point, exculpatory documents critical to her defense that the state never saw fit to even obtain, including cell phone records to refute the state's call pattern claims, and some past records to refute the state's unsubstantiated and inaccurate suggestion of a money drop, were lost to foreseeable document retention policies, causing a substantial prejudice to her defense. Accordingly, the indictment should be dismissed as a violation of Mrs. Adelson's due process rights. But if the court is unwilling to do so, at a minimum, it should preclude the state from introducing evidence that Mrs. Adelson can no longer defend against because of the state's charging delay. Background. Professor Markel was murdered on July 18, 2014. Within hours, the state located his former wife, Wendi Adelson, and brought her to the Tallahassee Police Department. During the hours-long interview that followed, Wendi confirmed that she and Professor Markel had been embroiled in an acrimonious divorce and that her parents, her mother included, were, quote, very angry at him. From that moment on, Mrs. Adelson was one of the principal targets of the state's investigation. Over the ensuing weeks and months, the state, joined by the federal government, devoted substantial resources to its investigation to support its theory that Mrs. Adelson was part of a murder-for-hire conspiracy. The state questioned witnesses at length about Mrs. Adelson and her relationships with Wendi and Professor Markel. it subpoenaed and combed through Mrs. Adelson's personal and business financial records going back to January 2013. It reviewed hundreds of emails between Mrs. Adelson, Wendi Adelson, and Charles Adelson. It reviewed Mrs. Adelson's calls and text messages, having filed applications with the court to obtain call detail records for cellular phones belonging to Wendi, Charles, and Harvey Adelson. Although, curiously, a similar request was not made for Mrs. Adelson's phone. And of course, in 2016, it conducted in-person and wiretap surveillance of Mrs. Adelson as part of the month-long undercover operation known as the, quote, bump. By May 2016, the state had in hand virtually all of the evidence it is likely to present when Mrs. Adelson's trial convenes next month, almost a decade later. But the state did not charge her in 2016. Instead, it made the strategic decision to pursue charges against the shooters and Miss Magbanua first, hoping that they would plead guilty and reveal what the state believes was Mrs. Adelson's involvement. But that did not happen. And so, Mrs. Adelson remained uncharged through two trials, one in 2019 and another in 2022. The state also failed to charge Mrs. Adelson when it charged Charles Adelson in 2022. Once again, the state chose to delay. It wasn't until after Charles's conviction, with no new evidence to bolster its case, that the state brought charges against Mrs. Adelson on November 15, 2023, 9.5 years after Professor Markel's death. Discussion. Number 1. The state's 9-year delay in charging Mrs. Adelson warrants dismissal under the Due Process Clause. As both the United States and the Florida Supreme Courts have recognized, inherent in the right of every criminal defendant to a fair trial is the right to be charged by indictment or otherwise in a timely manner. While statutes of limitations are the, quote, primary guarantee against bringing overly stale criminal charges, unquote, they do not, quote, fully define defendants' rights with respect to the events occurring prior to indictment, unquote. Citation omitted. United States versus Lovasco, 1977. Citation omitted. The Due Process Clause of the Fifth Amendment plays an important role in protecting defendants against, quote, oppressive delay, operating as a safeguard against actual prejudice to a defendant that comes with the passage of time. Howell versus State, Florida 1st District Court of Appeals, 1982. Even indictments brought within the limitations period are subject to dismissal where the delay departs from fundamental notions of fair play. United States versus Foxman, 11th Circuit, 1996. When the pre-indictment delay, 1, causes, quote, substantial prejudice, unquote, to a defendant's right to a fair trial, and 2, was the product of, quote, bad faith on the part of the state, unquote, dismissal is required. Jackson versus State, Florida, 2022. Mrs. Adelson satisfies both requirements. A. Mrs. Adelson is substantially prejudiced by the state's 9-year charging delay. We anticipate that the state will present evidence through Tallahassee Police Sergeant Christopher Corbett of calls and text messages clustered around events of obvious significance. The murder in 2014, and what the state has characterized as the first murder attempt in June 2014. And opine that these clusters, which include communications to and from Mrs. Adelson, are consistent with her participation in a murder-for-hire conspiracy. The problem with the state's theory, however, is that its sample size is far too small and biased. That is, the state's analysis only included cell phone activity between May 2014 and July 2014. Had the state looked at a broader time period, one that began in 2013, for example, or even earlier. It would have seemed similar call patterns clustered around dates and events that had nothing to do with Professor Markel's murder. These earlier patterns would prove that whatever Mrs. Adelson's communications were around the time of the murder, they were part of a larger pattern of calls and text messages between a mother and her family, not a murder conspiracy. But the state never sought to acquire call detail records for any period before May 2014, although it easily could have done so in the same way that it obtained Mrs. Adelson's financial records, dating back to January 2013. Since Mrs. Adelson's indictment, we have attempted to gather those records, but they no longer exist. Predictably, none of the private cell phone carriers retained records from a decade ago. Equally, if not more prejudicial, the state will likely argue that on the night Professor Markel was shot, Mrs. Adelson drove to Charles Adelson's home for a money drop. Never mind that Charles Adelson has previously acknowledged that the money paid to Ms. Magbanua that night came from his bedroom safe. The state likely still will speculate that this fictitious money drop occurred, and it will attempt to bolster its guesswork through a single text message sent from Mrs. Adelson to Charles Adelson on July 18, 2014, which reads, quote, "outside your house," unquote. Once again, the state is wrong. Mrs. Adelson was never at her son's home that night. Instead, she and her husband were driving from Miami to Tallahassee to be with their daughter and grandsons in the wake of the shooting. Records from Mrs. Adelson's son past transplanter would easily prove that, but the state failed to obtain those records, and the defense cannot. The state served multiple subpoenas on the Florida Department of Transportation for some past records related to Sigfredo Garcia and Luis Rivera. But the state, aware that Mrs. Adelson routinely drove between Miami and Tallahassee to visit her daughter, including on the night of Professor Markel's murder, never tried to secure similar records for Mrs. Adelson. Not surprisingly, the Florida Department of Transportation no longer has these SunPass records, which could have easily been obtained by the state in its investigation. Moreover, had Mrs. Adelson been charged in a timely manner, she would have been able to obtain those records, which would have ruled out any possibility that she stopped at Charles Adelson's residence. The records would have shown time and location entries of her vehicle on the turnpike and would have shown that the state's dangerous guesswork is wrong. Because of the state's 9-year delay, Mrs. Adelson is once again left without critical exculpatory evidence to defend herself on this critical issue. Excuse me. In a due process context, the substantial prejudice requirement is met where the state's pre-indictment delay renders key exculpatory evidence unavailable to the defendant, materially impairing her ability to defend against the changes. Oops, that's a typo. I pay a lot of money for these types of legal pleadings. That's a typo. Spelling errors really get to me. To defend against the charges. Scott v. State, Florida, 1987. Reversing murder conviction after concluding that 7+ year delay in the prosecution, during which records that would have supported the defendant's alibi were lost or destroyed, constituted actual. Okay, actual what? There's another typo there. Okay, I need to get a partial refund on my legal fees. State v. Ellis, Florida 3rd Court of Appeals, 2019, finding trial counsel ineffective for filing to seek dismissal based on pre-charge delay where potentially exculpatory surveillance video recordings were destroyed. State v. Hope, Florida 1st District Court of Appeal, 2012, finding actual prejudice where exculpatory evidence was lost due to the passage of time. See also United States versus Minkinen from West Virginia, 2023, concluding that the defendant's inability to obtain exculpatory documents, long since purged by the relevant state and private entities, constituted substantial prejudice resulting from the government's delay in initiating prosecution. The state's charging delay in this case has done just that. It has crippled Mrs. Adelson's defense because the only documents capable of undermining the state's theories, SunPass records and call detail records prior to May 2014, are no longer available, lost to the passage of time. Footnote 1. My Wendi loves footnotes. Number 1. The state may argue that Mrs. Adelson is merely speculating about what the SunPass and cell phone records might have shown had they been preserved, and that speculation does not give rise to substantial prejudice. But as the third DCA has held, a, quote, a negative inference cannot be drawn against the defendant based on the state's failure to secure evidence, unquote. State v. Ellis. Also, the records absolutely would have shown her time of location and entrance on and off the turnpike in question, showing that she could not and did not appear at her son's house on the evening of July 18, 2014. Okay, subsection B. The state's delay in charging Mrs. Adelson was in bad faith. The second part of the due process analysis requires a showing that the state's pre-indictment delay was the product of bad faith. But bad faith in this context does not require a, quote, subjective sinister motive, unquote, on the part of the prosecution. United States v. Foxman. Rather, it is satisfied when, quote, the government makes a judgment about how it can best proceed with litigation to gain an advantage over the defendant, and as a result of that judgment, an indictment is delayed, unquote. That is precisely what occurred here. Rather than proceeding against every member of the alleged conspiracy at once, the state sought separate, staggered indictments, betting that the earlier charged defendants would implicate Mrs. Adelson. None did with regards to Mrs. Adelson, and an indictment against Mrs. Adelson did not follow for another 9+ years. This was not an investigative delay of the sort sanctioned by the Due Process Clause, C, e.g., United States versus Lovasco, 431 U.S. at 791. Virtually all of the evidence the state is likely to present at Mrs. Adelson's trial was in hand long ago. The state's charging delay was strategic and in blatant disregard for Mrs. Adelson's ability to defend herself against allegations nearly a decade old. See United States v. Foxman, 87 F. 3rd at 1223, noting that a court should have, quote, little difficulty in permitting the foreseeable Okay, I think there's a typo there. The foreseeable of a deliberately chosen litigation strategy to be visited upon the government, unquote. Number 2. Should the court decide not to dismiss the case, the court should preclude the state from introducing evidence that Mrs. Adelson cannot refute because of the state's charging delay. Should the court determine that the state's charging delay does not warrant dismissal under the Due Process Clause, it should prohibit the state from leveraging its delay by admitting call pattern and text message evidence that Mrs. Adelson cannot adequately address and refute. During the course of its investigation, the state gathered evidence selectively, choosing not to obtain call data records for any period before May 2014 or some past evidence for Mrs. Adelson's transponder. Now, 9 years later, that evidence is no longer available to the defense through no fault of its own. Fairness dictates that the state should not be allowed to present call pattern and text evidence to a jury text with determining Mrs. Adelson's fate when, because of the state's own delay, evidence that would refute the state's claims has been destroyed and is no longer available. Conclusion. The state's tactical decision to wait 9 years after Professor Markel's murder to indict Mrs. Adelson has substantially prejudiced her ability to defend herself. She can no longer obtain material exculpatory evidence concerning call patterns and her location on the night of July 18, 2014, a foreseeable consequence that the state took no steps to mitigate. Accordingly, the indictment against her should be dismissed under the Due Process Clause of the Fifth Amendment. Alternatively, the state should be prohibited from introducing location and call pattern evidence and certain text messages at trial that she can no longer adequately refute because of the state's charging delay, dated August 12, 2024, respectfully submitted Marcus Neiman Rashbaum and Pinero, LLP. Okay, I know it's a shot in the dark, but I hope that there is a chance that Judge Everett does rule in my favor. Okay, that was fun. Hope you guys enjoyed that comedic, dramatic reading of Donna Adelson's motion, which I think should fail. And thanks for tuning in. Hopefully I'll come up with some more content later this week. Justice for Dan. Thank you.